Let the matter be called up. Pass it. Let the matter be called up.
Lordship, I did 6 and 7. I'm waiting for a response. Lordship, I want to see a little accommodation. Lordship, there is the top of the list case. So, Lordship, some accommodation. Lordship, because top of the list case, it may clash with that case. Lordship, maybe call up to sometime. Lordship.
Top of the list where? Keep this.
5. Item code number 5.
Okay. Item 6
6
and
and
7.
7. Lordship.
With the request of MS D. Sharma, London.
Lordship, I'm not praying for adjournment. I'm only seeking a little accommodation.
For today.
For today, I will be because I have not taken consent from other side of adjournment. It may
All
clear
right, all right.
in their details.
Okay.
Okay.
Huh? You file it, it will come automatically. What? 85, you file it. Have you filed the bill application? So if you file it, it will come on its own. It will come on its own. It's a fresh matter. Fresh, new matter. I didn't get it. Yesterday you filed. No, it will come on its own. Don't make a mention. You have filed it yesterday. It will come on its own. By tomorrow or day after, by Friday, it will come. If it doesn't come, then you make a mention. Okay.
Item number 8, but I have to file an additional litigation.
Who's for the APP? Yes. What additional affidavit?
This is second application. I have to bring on notice in the earlier litigation.
All right. Item 10 at the request. Item 10 at the request of Mr. M.I. Hussain. M.I. Hussain. Matter stands adjourned for 2 weeks, enabling him to file an additional affidavit as prayed for. Mr. R.R. Kaushik appears for the London APP, appears for the state.
This is a file of documents item number 17 and 18.
Yes.
With that function of the candidate, of the
17 and 18 after 2 weeks at the request of Mr. G. Decca.
Yes.
Learned counsel is getting for the petitioner and the review petitioner. Anyone for the respondent?
I will put a petitioner in 17.
All right. Have you informed the petitioner's counsel?
Yes.
It is submitted that the counsel representing the respondents is in bereavement. Therefore, adjournment is prayed for. Prayer is allowed. Matter be listed after 3 weeks. It is submitted by Mr. Govildar and a counsel making a mention on behalf of MS R. Devi. That consent of the petitioner's counsel has also been obtained.
Item number 20 also.
20 also. Also similar prayer. This is 2016 matter.
Okay.
Item 9, we are adjourning it for 3 weeks. Item 20, we are passing it over only for the week because it's a 2000 matter.
For a week.
For a week.
Item
Item 20, the request Mr. Govildar matter be listed after a week.
update on item 16. It is just where you get to the real subject for item 6. Item 16.
16.
Yeah, that is from after the
Your next thing. Item 16 at the request of Mr. H3 matter stands adjourned for 1 week. 2 weeks. Adjournment slip countersigned by the council for the other side has been circulated.
Not even word, you can put your calcium, TT and certificate, but that was not.
Item 21, in terms of the earlier order, dated so and so, silent order. Scan copy as called for has not been received, matter be adjourned for 2 weeks.
Can you please not do this? Do this.
No, first week of August.
Daily list item number 1.
Yes,
In also this case, these who is appearing and there is some links in Potna one look change.
it's on a very simple issue, it's on a very simple
I
issue.
have admitted to the fact that they will be giving me the financials.
On
That
Thursday,
much only, madam, they
on Thursday, what?
Not on Thursday, this is a
Or if
2012.
Today work, but. Or there's some difficulty.
Madam, we'll have it,
On Thursday also.
All right, Thursday at the request of MS Bora.
that instruction, madam, which if they're affidavit, they're said they're giving me the financial. That
Standing
much
counsel.
instruction she can have.
You are now praying for financial benefits.
Naturally,
That's
I'm
the only
planning.
thing.
Thursday on Thursday.
If they give me the scale of the principal, I get something of the, madam. If the
Otherwise, you are getting the scale of what?
Vice principal,
Vice principal.
twice, madam, they do. And one, another.
Is there a provision for career advancement or something like that?
No, but that time it was not there. They, one Mudin Decker was there, madam, his case naturally, but they can't just, because I was holding the charge, they cannot give it. But one Mudin Decker similarly situated, madam, his services were regularized to cabinet, and my lord, he was given the scale of difference. Whereas in my case, they are not. They waited for me to retire and then advertised. And twice, once I went to, once I was in Dibrugarh, came back. Then they opened the Corpeta College, I was put in charge there. Then there was unrest in my lord Dibrugarh. They took me to Dibrugarh as a, my lord, principal. I controlled that. Then I retired. They extended my services in 60.
Extended,
Then I re-employed
re-employed as what?
as principal.
As principal,
Principal.
in the same scale.
No, in the scale of vice principal.
And
They allowed me to continue as principal, but I was given the scale of vice principal. Only to that extent, some money he gets. Thursday.
Thursday, yes. Thursday.
Like,
Item number 2.
Thank you very much. The mobile of traffic. Have been removed from the
From FCI.
FCI, I was in charge.
Now, on what is the ground on which you challenged the removal?
Now, my lord,
There was some stock found to be misplaced.
access, my lord, in fact, after.
What is the meaning of excess stock?
My lord,
What is the meaning of excess stock?
How access from the book value. He has given a declaration.
Meaning the stock available in the warehouse.
No, but it happened like that. The head in charge, they show some transit loss or storage loss. And therefore, the stock that amount of loss is reduced. Actually, this was not loss. That's why the PV team found,
That is what I was trying to
that is why when the PV team.
understand, that excess means in
Access,
the register, whatever quantity is there
yes,
or is shown to be lost or damaged
yes,
is actually not there
no,
upon physical verification.
yes. And if it is not otherwise, you know, some extra gunny bags are to be issued and spillage, this is not there. That's why you will find in the impugn order, punishment order, it is given in detail. And the appellate order also, they have to challenge the appellate order.
By repeal method,
Hmm.
that has not been taken into consideration.
No, there he is he himself said appellate or appellate. In any case, lordship may look into the impugn order also. And petitioner even otherwise would have retired long back, 2013. Now will not,
All right, let us
he
see.
cannot be.
Yes, yes. Yes. What are the grounds that you are putting to challenge you are challenging the inquiry also?
But the impugn order is being under 47.
Yes. This is the order of the disciplinary authority.
What the date is under 22nd December 2021.
22nd,
What?
yes,
Next week, it's 47.
yes. You tell us where is the defect in the inquiry procedure? Is it a defect of procedure? Is it a defect on the basis of the appreciation of evidence?
The charge that I think whether it's the same method. When they're not. There is no evidence.
Yes. What is your ground to challenge this inquiry proceedings? You were admittedly the person in charge. There was finding on fact that there is a discrepancy in respect of the,
Page 49, but
yes,
all the discussion under the. Of their two master. Now their two, the side being the. Then it's the. Who? The division. Before we had, the website is not division. From the circular to we have shared with the board. Website. The from the survey of the preparation of the effect and the further direction of the future. And the
you are not addressing the court, Mr. Counsel. What is your case?
Paragraph 7 of 17 paragraph at page 15. Ground is the our first paragraph.
Yes, page 17 of
Petition.
writ petition.
What?
Yes, page 17.
What paragraph 17?
Ah,
But the petition of the state is the same. What are now what it is so. They did two second back. So we can petition and continue to take.
you are reading from which paragraph?
17.
Paragraph,
Paragraph 17. And page 15 of the petition.
yes. Yes, please.
The color, petition of the state with the same. Number 5, dated 15 to 2010, not the president with the group. Department of directing state to the heart of the state of the group. Page 2.1. The same grade 1. About in rank, then the petition was also posted at check number 4. Of FCI. Against the armor to provide the review of unloading. That is to provide the income stock of all goods with record. You are responsible for looking to see the all stocks unloaded at check number 4. I can't say for that, even the material here.
When were you given the charge?
But
When did you take over?
taking charge number. Yeah.
Hmm. You were taken charge on 2010. And when was the inquiry conducted? When was the stock verification conducted?
I think it's 2010.
Hmm?
4800.
48.
4800. 48.
You were responsible to maintain the register with the correct information.
I'm like grade 2 minor. 2 minor. Only grade 1 there. Responsible for the all different meta model. I was start later on.
Correct. During the time that you were holding charge, did you not notice that there is a discrepancy between the register and the actual amount of stock?
No, my lord, I was forced to take charge from it.
Hmm?
I was charge on it. Ever the complete employment. Return I have given. this time.
Whatever may be, but you were given charge.
So,
When during the period under which you were in charge of the shed. Did you not make any inquiries or did it not come to your notice that there is a discrepancy between the register and the actual amount of stock?
no, that's, I have, consultant, there are 90 of the petition. But the petitioner, may I? Had it.
Yes, please do.
The petitioner had stated, the estimating act of that. The charge of sleep from the court or given to the petitioner. Only on the 2010, without the invasion of faith, stock as particular procedure of FCA. The people of Indian political secure position without. And all there is excess of with 144.11 and profit or gain of subscribe to the king of the 3,16,610. Only, and the critical verification view without mentioning the or reason. of such
You
gain.
take us to the inquiry first. Let us go to the inquiry report. Where is their inquiry report?
Income is over 36 now.
Yes, Mr. Roy Chaudhary, Mr. Roy, sorry. What was the finding ultimately in the inquiry?
My lord, he has found that Melody find the page 42. He has given his finding, but disciplinary authority will not take into consideration the, not only the inquiry report, charges, evidences, all material record, and ultimately
No, what was the finding in the
finding
inquiry?
it page 42, my lord.
Yes,
Though, my lord, last para is a very quick take, but then page 42 found the statements of the above witnesses. Page 42, my lord.
Yes.
Below the witness, the witnesses. Above witness, it is well evident that during PV by the regional office FCI Guwahati, the T20 packet could be found access at top stake number 12 and on 100% payment operation of the same T20 packet has been confirmed to 125 tons of winter access. And the stack of the check of 100% payment being deputed to the area. This is the finding basically. After considering the evidence.
finding is that there is an excess of 320 packets of wheat in the shed, which is not found recorded in the register.
Yes, it doesn't match.
It doesn't match. Now, what is the effect of that?
Effect.
So far as the employee is concerned.
He has, FCI concerned, he has shown it as a storage loss.
So where do you find it from the inquiry report?
So storage gain, I'm sorry.
Hmm?
Minority find it at page 40,
Yes.
storage gain, I'm sorry,
Show this,
storage gain.
which,
Page report of district commission. Minority will detail loss will find in the impugn order. If I read the impugn order, my lord,
impugned order is based on the inquiry.
based on this, not only on the, but on the, when the disciplinary passes an order, he not only considers the inquiry report, he considers the evidences and record.
Correct, but the inquiry report is the basis.
Yeah, that is,
Right,
that's
so
primary.
first let us
Minority
see
kindly see
what came out in the inquiry.
the minority page 40, equality please. Report of the district committee.
Yes,
Book number 4A in page 007, as per order of the area manager DO Filter by Franco. District committee head of the Orun Day manager depot conducted production 100% payment of 775 quintals against stake number 3 and detected 775. So as storage gain against declaration of book value.
what is the meaning of storage gain?
Well, when it is found access, this is storage gain sometimes storage gas is marginally gain.
Storage gain is that the quantity recorded, there is an excess quantity
Access.
over and above the quantity found recorded in the books. That is how, can we
Yes.
describe it as like that?
So this huge, there cannot be huge storage gain.
No, whatever, but
Use-
there is some storage gain,
Yeah, storage gain.
storage gain.
Against so and so book balance.
Amounting to
This
one-
record found maintained by SR2s. From the
Yes,
above record, it is established the regional office team number team on peripheral counting at shed number 4, Ramnagar detected excess of 320 with stack number 12. So subsequently, the district committee team detailed in area manager 12 when supervised the 100% delivery operation women of the stock. September detected 320 excess value of so. Thus, both the PB team and ROT operation team from the DO confirmed excess occurred of wheat value of so. So if my lord will kindly have a look at the order, that the position can be, my lord, understood clearly.
yes. Page number,
Well, input order is at page 42.
Yes,
I read the entire input order. my lord,
please do.
Because there is something which is very technical, my lord. Page 47.
7.
Whereas disciplinary proceedings under regulation so and so, Kaipur Raja, the then shed in charge, shed number 4. Also by memo number so and so, due to excess 320 of wheat stock. Whereas Kaipur Raja Chaudhary submitted his implied defense by representation dated so and so. It was not possible to collect the stillage grain of rice, wheat during last quarter due to jam-packed condition of all the chamber of shed number 4. After June 2010, it was collected and backed as space position of the godown was improved. The spillage grains of wheat collected from different chambers and kept in take number 12. But due to oversight, it was not duly reflected in the stack ledger for which they access. This case is there is some spillage. Number one, whereas the inquiry was ordered by Manuswell. After examination, cross-examination, CO as also PW, the inquiry officer submitted his report. The facts and circumstances supported the concerned record and the statement of witness, the article charges framed against Kaipur Raja, is there in charge shed number 4, dated found with proof. Whereas a copy of the said inquiry report was furnished to also. In response, Kaipur Raja submitted number 1. The only pertinent fact emerging from the inquiry report is that there occurred an excess food grains at shed number 4 of Ramnagar, and whether or not there is any material to prove or even to suggest complicity of the charge official to excess, that is what has not been proved in the inquiry. The IO, without any application of mind, has abruptly come to the conclusion with the charge and found proof. The IO did not show any reason in report to Sansu. This is a departmental inquiry and therefore established guilt. The primary factors, the circumstances from which the inference of guilt is drawn are duly proved and direct oral and documentary evidence. There is no missing link in the circumstances evidence. These are his evidence. Whereas an opportunity of personal hearing has also been given to Sansu. And he has submitted as answer. M. Chaudhary said that he had holding the charge of shed number 4 Ramnagar from February 2010 till completion of 100% payment of stock in the shed number 4 on. Sri Chaudhary has stated that there was no shortage of stock during the quarter PP declaration given during 36. He replied the access of 320 bags is correct. The detection of 320 bags of wheat was caught against the declaration undoubtedly correct. S.R. Chaudhary stated the reason of access clearly elaborated on his reply dated 12. I have already explained the reason for access in my reply 12. Lastly, Chaudhary has kind sympathetic consideration for it. I have gone to the chart sheet, replies there to EV report, IO report, CO submission against the IO report, relevant spot record from the report record, namely stake ledger, money ledger, etc. Factum of 320 bag wheat detection arrow, team on Celso and 100% weighment of wheat stocks undertaken by team. It reveals that now is finding a lot. Sri Kaipur Raja Chaudhary was holding the charge of shed number 4 Ramnagar from February till completion of 100% weighment stock at shed number 4. Kaipur Raja Chaudhary AG2 had given the declaration of stock PV as on 23/7/10 opening balance, as well as during 100% weighment undertaken on 28/10/2010 by RO Squad and the team from DO Filter respective. On verification of stag S4, it reveals that while ROPV team visited shed number 4, FSD Ramnagar on 23/7/2010, there were only 2 numbers of wheat stack. UA43, 455 bag, UA410, 534 bag. As per the book balance, as well as declaration of stock as on 23/7/2010, given by Kaipur Raja Chaudhary. the then IO 20. These two stacks remain intact with effect from 36 to 23, 610 up to 2810. There was no operation then. Since there was no operation of wheat in stock number 4, after conducting physical verification of peripheral counting of ROPD team, 775 bags wheat of stack number 455 for balance of stack on offering in access with wheat. Originally, the stack of U43 was built on 10/5/2010. The original bags received in the stack was 1391 PS, and after the saving of 7 pieces of unserviceable gunny bag received closing balance as on 10/1/2010 shown as 1384 bag. After issue of 922 bag with 2 PDS during June 2010, the closing balance comes to 455 bag. From the record, it reveals that all the wheat stack stock except the stacks at stack numbers 2 and 2010, which are received during February to June 2007, has already been issued out within May 2010 to June 2010, declaring nominal storage gain or without any loss by saving 395 pieces of gunny bag. As such, the question of further collection of spillage gain from all these stakes after June and brought to account tag number 3 does not arise, because loss gain could be ascertained after collection of spillage gain bleeding from the bags during the handling of the bags at the time of issue of a particular stack. As per accounting process, spillage grains collected from a particular stack should be accounted against that particular stack issue itself, and it cannot be brought forward to other stacks. So the submission of Mr. Chaudhary here in his defense reply cannot be accepted. From the gunny bag, the gunny ledger, it is evident that consumption of 320 pieces of empty gunny for refilling of spillage grains of wheat is done after detection of 320 bags of wheat against the declaration of stock as well as empty gunnies. It was done after that. It is also evident from the Jute account that there was no stock of Jute twins in 2010-2004. As such, there is no consumption of Jute twin for stitching the bags after refilling the empty gunny bags with spillage grains of wheat collected from other
So,
stacks for June 2010.
Mr. Roy,
2010.
Mr. Roy.
Access wheat of originally.
Mr.
lying
Roy,
Lost it.
yeah, so essentially what has happened is that there are some discrepancies noted.
That
Now, what was the loss posed to FCI?
loss is that amount is given below 3 lakhs, this particular account, the amount is given below already.
No, that is the market value. That is the value of the excess wheat. Now, in terms of losses, how do you infer the losses from the excess wheat? So far as FCI is concerned, how has the delinquent officer caused loss to the FCI?
Because this, if this, there is no account of this particular 320 bag. This has gone somewhere.
No,
Therefore,
how can it go? Because your physical verification team has found that number of quantity in the shed. It has not gone out. The allegation is that the records which were available, the number of bags which is recorded in the register is lesser than the number of bags available in the physical verification. There is an excess of 320 bags which are not there in the record, but the bags are available in the shed. Otherwise, they could not have found it out on the physical verification.
that's right.
So if that be the case, then on the date when the physical verification was conducted, there was no pilferage of these bags, either by the petitioner or by any other person. Where are your rules which govern the service conditions or the disciplinary process?
One of the charge has been framed under, he has been showing misconduct of rule number 31A. My lord, you kindly see the rule.
Are they available in the pleading?
Yes,
Page number?
I have a copy of that.
Okay. You have the rules?
I have a copy of that. But this is my lord, this is the rule. My lord, you kindly have a look at it. He was charged with violation of regulation. 31A, 32A is very relevant, my lord. He must pay attention to every transaction. That is not very relevant. 31A is of integrity and all. Then my lord, 32B, 31AB and 32A.
32A.
A would be relevant, but he must pay attention to every transaction. That is,
32A is misconduct.
yeah, 32, lordship, you can remember, my lord, 32 capital A,
Misconduct.
misconduct. Misconduct, that is the chart, my lord, at page 32 of the repetition. He was charged with this misconduct. He must pay attention to every transaction, as he was a third in charge. Even if it is without excess or loss, he must pay attention to it. And 58 is the relevant regulation, you know, 58, under which proceedings for the and the misconduct.
Under 32 capital A, which sub clause is retracted so far as the petitioner is concerned?
Capital A, one of he must pay attention to, lordship will kindly see that capital A.
32 capital A is misconduct.
And above that,
32.
32, what it says, Lord, I think that attracts most. He was a shedding.
That is what I'm trying to understand. How has it affected the interest of the corporation? This particular loss, Mr. Roy,
No,
see, admittedly, there is some discrepancy. Now, this discrepancy may attract some form of displeasure from the authorities, stoppage of increment, reduction of salary, or maybe suspension or something like that. But does it attract the penalty of removal from service? In a sense, when you find out as to what losses ultimately has been caused to the corporation, There is no finding, there is no evidence.
I understand, but that's. But
Although strictly speaking, this is not the pleaded case.
lordship. Now, what I then may not be lordship if it is in the quantum. May not may leave it to the authority.
No, leaving it to the authority, but under what provision?
No, may not.
First, we'll have to find out. First, you'll have to
But
show us.
at least may not, even if there is no law, assuming there is no law, there are anomalies, discrepancies.
Correct, there are anomalies, discrepancies, but for all discrepancies, you are not going to throw all your employees out of the corporation.
No,
This is not a case, this is not a case that where he is the only employee
No, but
who's.
My lord, I can show to you lordship the
Ah.
duties of a shading.
Ah.
My lord, he is the main man. He is in charge, head in charge.
No, I understand that. What I
No,
want to
others-
know,
others-
what I want to know
Yes.
is how has the corporation found it to be a misconduct in view of the discrepancies? Because you'll have to relate it
Yes,
to the losses caused to the corporation.
no, not even if it is, there is no loss.
If
Even
it
assuming
if it is, there is no loss, then you can rectify it.
No, my lord, rectify means,
Is there no incident?
I mean, my lord,
Is there no case in the
I am
FCI?
not sure, my lord, about the loss, I can, my lord, about the law. I can obtain instruction really whether the, but how.
No, your instructions are irrelevant because we are going only what is evident from the inquiry report.
No. No, my lord, there has to be some loss, otherwise, my lord, that's true.
Yeah.
But since it is a very technical thing, you know.
You cannot improve on the inquiry report now.
My lord, I think the.
There is, see, if you look in, do you have another set of copy?
My lord,
Do you have another set of copy?
I don't have right now, but I can give you lots.
Okay, no, we can get it. What I wanted was to refer you to the various clauses under 32A, which make out a misconduct.
They have said 32A,
Hmm.
15930.
One is
Five.
theft, fraud, dishonesty. There is no
Five.
theft, there is no fraud on the evidence. One, then
9 and 30.
5 is acting in a manner prejudicial.
Okay.
So there has to be a finding that this has caused prejudice to the corporation. 9 is neglect of work, negligence in performance of duty,
That, correct, my lord.
maybe, and
30.
30. Act unbecoming.
That
How is it unbecoming?
is shedding shed. And I think the broad, since he is a shedding shed, and then the duties assigned under the rule.
Where are the duties?
Duties were assigned.
Well, this is what assistant grade.
Yeah, my lord, there are various.
No, we are not, there is no dispute. Perhaps on facts, that there is a discrepancy in the register. He ought to have maintained the
As
correct
as a shed.
as a shed in charge.
That,
Now the
that,
question is whether that entitles to removal from service.
that of course, the lordship, I have to leave it to lordship, that I have to leave it to lordship, but I cannot. And if the lordship finds that removal is.
No, because you have proceeded against him alleging misconduct. You have started with number one, which is theft, fraud and dishonesty. There is no evidence of theft. There is no evidence of fraud. There is no evidence of dishonesty also with reference to theft or fraud, or with reference to likelihood of commission of theft or fraud. Had it been a case that
Independent of theft. That may be
Dishonest.
independent of,
no, dishonesty has to be understood
in the context of.
in the context of causing loss,
law.
either by theft or fraud, or by forgery or something like that.
Dishonesty has to be understood in the context of performance of duty.
Performance of duty, no, there is a
Everyone
difference.
must be honest.
No, there is a difference between failure to perform duty and failure to perform duty with dishonest intention.
There is a difference. There is. There is. But every employee must be honest with.
Correct, but this honesty you'll have to gather it from the basis of the evidence to say
That's right.
that the whole purpose of
If I
causing
say that-
this excess was with the intention of causing loss
Right.
or
No,
theft.
if I say one must be honest, there has to be material to show that he is dishonest.
Dishonest.
That is what, there are material to show.
So this is number
But
one.
I think we not,
Number 9, perhaps neglect of work,
that,
negligence.
this is apparent, my lord. And the defense has taken also. The inquiry officer as well as the district officer found to be not tenable.
Then what is the, how do the authority arrive at the punishment? What is the principle? On what basis the authorities will arrive at the punishments? Because you see, there are minor penalties, major penalties. Following penalties may be imposed for good and sufficient reasons.
My lord, it says the district officer says, at page 49.
Yes.
Considering all the facts and circumstances, page 49.
Yes.
Considering all the facts and circumstances, the undersigned is of opinion that the findings of the vehicle inquiry officer confirm standard proof that is required to be established and guilt of the charges of vehicle Saifur Raja, shed in charge of charge number 4. Hence, it is established that Muhammad Chaudhary procured these 320 bags of wheat by adopting malpractice.
This is
Ulterior motive.
this is where there is no finding. Where is the finding that he has arrived at?
For
Ulterior
motive
motive.
of personal gain. I mean, I think Lord, your lordship is right that the crops are there. His intention was to, my lord, ultimately sell it
On what basis have they come?
because if it is excess,
That is a suspicion.
now showing, my lord, transit law, storage law, he made this. Showing transit law, storage law, he made this access law with the ulterior motive of personal gain, personal.
So what you are trying to say is that
To hide out the fact during the quarter ending, sir, and he has reflected the correction to with the ultimate object of selling this to the market. But he has made this access stop. by manipulation of record. That is what the finding is.
Where is his reply? Where is his reply?
Reply to the chart below.
Yes,
Yes, my lord will find it at page 30,
30,
30,
34.
34, he says. With reference to the subject stated above, it is to inform that during the last quota, all the chambers of Act number 4 had sufficient rights and speed wagon. Owing to fact of space problem, during that, he couldn't prove that during that period, SHS gunny spirit grains of both rice and wheat was not possible to collect, bagged and stacked. After the month of June 2010, it was being possible to collect back as space for position of go down has improved and issue out of sufficient quantity of stock to go. Steel grains of wheat collected from different chambers of stack CC has not been duly reflected in the stack ledger through oversight for which the access back have been noted. Moreover, Sri Shambhu Gaur AGP was given responsibility to look after the stock of the chamber 1. I asked him about the account and stocks of chamber 1. I did it all. He said it is all right for reasons. I did not count this stock. This is misconduct, my lord. However, the state access back will be taken into account. Actual storage gains will be reflected. This is what it is. He said there was spillage. Then he could not come up with material to show that there was spillage. If there is spillage, there has to be some extra issue of gunny bags to fill it up. To fill it up. That was not there.
Now, what is the meaning of this page 34, second paragraph?
Going to space problem. That period storage of that is period grains of both rice and wheat was not possible to collect. There is a space problem, you see. He should have proved, my lord, there is a space problem.
No, no. What is the import? What is the meaning of this sentence? What is he trying to,
He is trying to say,
say?
because of shortage of space, there was spillage of food there. The excess stock there. So it is kept in stack.
No, no. Your physical verification team verified and recovered what? Gunny bags, bags of wheat.
Means the gunny bag. Just say if the
No.
gunny bags are kept in stacks.
Correct. See. The physical verification team, upon verification, what did it find? Did it find the wheat in the bags or is it wheat kept in the open?
No, in bags.
In bags. So. The statement of the petitioner that he is not able to collect or debag has no correlation with the wheat which has been found by the physical verification team.
No,
So
No correlation.
if this spillage was collected in a bag or stock, then it would have been over and excess, over and above the excess wheat which was discovered by the physical verification team. Is that what the corporation would have interpreted?
no, he said, my lord, in this ultimate, what I understand from his reply, what he wants to say is that since if there is huge spillage, he has made this, kept this in the bag, and that is how the access is.
Then he has done whatever he has done.
No, that is, but that is not a fact. There was no spillage. If there is a spillage,
Uh,
if there is spillage, he has to keep on the same stack. He cannot keep it from different. That is what the finding is. And if there is a spillage, the accounts show there is an issue of gunny bags. That is the inquiry did not find. There is no gunny actually show gunny bag. Because this extra from the spillage has to be put in a gunny bag, which should be issued.
No, but he has made a statement that kindly come to the bottom of page 34, last line.
Different chambers,
No,
different chambers.
spills, spill grains
Yes,
collected from different chambers.
we collected from different chambers. This is also the disciplinary body cannot do it.
Why you cannot do it?
He must, from the same chamber, he must keep it to the same chamber. From the different chamber, he cannot collect.
No,
But through oversight, excess debt has not been noted. This is not because through oversight, in fact. And his defense was taken into consideration by the disciplinary officer. And passed it on, because they are the authority who will understand it best, his defense whether it's correct or not. This is something technical, with them only they will understand.
yes, does it mean that the corporation will wait for a pecuniary loss to be caused by an employee and only then they will proceed? They are within their rights to suspect that these bags were deliberately not recorded or kept in the record for being sold off, causing loss. But before that could be done, this stock verification happened. Why was the stock verification? Is it a periodical thing or you do it on
They periodically make.
periodically? So
Twice, but periodically make, and then on special, quarterly they make it. That is a team.
then your defense is that these were collected from various chambers. Please come to page 34. The spill grains were collected from different chambers. Anything more you want to say? Sorry, after hearing you for 1 hour. Who is not physically fit? Whose physical fitness are you referring to? The council. You are not physically fit. So we dismiss and close it and we relieve you of your trouble. Thursday, come on Thursday. Mr. Roy,
Can it be on Friday, then because Thursday have.
no, we'll hear him. We have heard him.
Oh,
We have heard you.
all right.
You can request your colleague to be present if required. If required, he can be present. We are retaining this rules. Thursday.
Item number 3,
Okay, to Thursday, you request also. Yes. Matter may be closed. I didn't get. Okay, it is submitted by MS Bora, learned counsel for the petitioner that the grievance of the petitioner does not survive as on date, therefore she has instructions not to press the writ petition any further. Accordingly, the writ petition being WPC number so and so stands dismissed as not pressed. Interim orders, if any, shall stand again.
Item number 4.
So instructions, we have given you time. We have given you some time. Now, you belong to that area, permanent resident.
Yes.
But the report of the CBPO says that this is reserved for ST.
Yes.
You are not an ST.
Not this.
Ah.
I belong to this.
Then is it reserved? Is that area reserved?
Yeah, no, it is in that practice.
Yes, Mr. Goswami.
In the rule, lordship word of above 40%. The community which is belongs to that area also. It is reserved from them. This is the rule. This is the.
So you correlate between the rule and the.
That regard, lordship,
Yes.
that regard, lordship.
Mr. Sorodia, is it reserved for the ST? You are for?
Lordship,
That's number 6.
lordship in,
Actually, but it's supposed to be reserved by that. Central matter, but without any advertisement matter. And game also like. But in the advertisement, there is no, there is not been shown. Otherwise, it's big term. Because we are 100%.
Yes, Mr. Goswami.
lordship, open lordship regarding that area lordship, although in the advertisement lordship, it is not categorically stated regarding the reserves. But after some deny the area lordship, when the election board obtained that it is 100% SC populated area lordship, and therefore they elect the ST candidate.
Where is that selection? Minute?
Now on that regard, lordship, we had sent the letter to the offered lordship. The instruction yet to be received, lordship. And if bring the matter in next week, lordship, I will come along with the enter instruction.
So who was selected? Respondent six.
Six, lordship.
You were selected.
Yes.
Mr. Soronia's client was selected.
No,
Then
no, not. Because it is not been selected, sir, my claim is she is not resident of that locality and she is not that. Over such revenue is for that, that's my thing, that is found to be denied by the inspector.
that she is not a resident.
She is not resident. Now, my understanding by a resident, I so that is that. Otherwise, the inquiry report says that she is not.
Where is the inquiry report?
Very good is page. I think it's 44. Page 44. Remarks on this last one.
And what are you showing by the additional affidavit?
Yes. And I'm seeing the document. Prior to the selection, I was the resident of the area. I got married with my husband in the year 2000. And since then, I've been living there.
You've been living where?
In the number 2 society now. It is under the list of the concern. Good, but
Page number?
is at the 86. 86, the type could be the vernacularly on its
Serial number?
scale number 1 could be.
140.
The number, not only the place is not only a polling station, it is a revenue village. It is a revenue village of. Then due to rationalization, later on, in my another studies, it is already annexed in the first MTV. It is clearly mentioned as number 2%. First, it is this total is in 2005. In that class, in this total list, my name has been enlisted with my husband. 2005, due to rationalization of polling stations. In the year 2021, the name of the polling station is mentioned as the number 2%. And in respondent numbers, lots of kindly see the page 76. The total list of in which the respondent number 6 name is enlisted. In the top, is clearly mentioned number 1%. It is issued by the election office.
$77, where is your name?
77, it is the serial number 340, 340, middle column. Biju Kumari column. This total is number 1%. So it is not legally entitled to get that.
But the committee says you are not a resident.
That is why I am challenging, it is a purpose document. Yeah. If I want to. One thing is the. Can you see that I could. The relevant parts. Base 31. And second paragraph, considering the submissions made by the learned counsel for the third parties and the materials on record, I am of the considered opinion that the use of justice will be made if the committee is constituted by the commissioner and secretary to the court of Assam in the social welfare department to look into the grievances of the petitioners. As reflected in the individual with reviews, it is submitted by the learned counsel.
No,
for the
we have gone through that. We have gone through
Yes.
that. So essentially, there is a committee directed to be constituted.
Yes, Lords. It is within a period of within 31st January 2020.
So that committee has been constituted,
First, after a period of
whatever, but
when it was constituted, sometimes ago,
no, but this page number 44
for years.
is a finding of that committee.
Yes, within findings of the committee.
Findings of the committee. Who is the chairman here?
So regarding the lordship is directed to take instruction. How it was found, whether the guidance of the High Court was followed or not, regarding the instructions. It is the direction of 2009, within the 31st January 2010, they need to compromise, but in the year 2016, they issued this letter regarding my review. After a period of 5 years.
Mr. Goswami, what is the basis of the committee arriving at this?
On that regard, I think.
We have given you sufficient time, you get your instructions or will be compelled to call your Director or secretary.
Last month, maybe it is treated at the last month. Next week, also, I will.
Mr. J.K. Goswami, learned additional senior government advocate representing the social welfare department. Praised for and is granted further 10 days time to obtain specific instructions with regard to the findings of the committee that the present petitioner is not a permanent resident within the jurisdiction of what is that? Number 2 Kakchaitang Kosaiti. Kakchai. It is written as a Kakchai. Kachaiti BC. Anganwadi Center in the district of Dhemaji. Full stop. From the report of the, what is this committee or subcommittee?
Subdivisional.
Subdivisional committee.
Second by the sub.
From the report of the subdivisional level committee. It is not discernible as to the basis of the findings of the same subdivisional committee with regard to the question of the permanent residency of the petitioner. Full stop. The learned government advocate will obtain all required instructions and place it before the court by the next date fixed. Mr. N.M. Hazarika, learned counsel for the petitioner, does not object to be read. Mr. Sorania, Manas Sorania, learned counsel appearing for private respondent. Number 6. You want to file any affidavit or?
File.
You want to file?
File.
Raise for and is granted some time to file their affidavit contesting the allegations made in the writ petition. Accordingly, the matter will be listed again on. When can you get it? Tell us.
It
28th, Friday. The additional affidavit filed by the petitioner is also available on record. List on 28th.
Number 5.
Yes.
Chief, I have yet to receive the instructions, Lord Chief.
No, this
I
will not like this.
discussion with the authority yesterday, Lord Chief, and they request, at least 10 days time.
No. This is, what is this? You are unable to give us an instruction as to
Because the record, they could have traced out the record.
how is it possible that the records cannot be traced out? That record will never be traced out. Who is supposed to give you the instructions?
The director has service.
We'll call him to court.
No, Lord Chief. At least, let me.
We are giving you time till Friday.
Tomorrow, Lord Chief, tomorrow.
We are giving you time till Friday. You get your instructions, otherwise we are issuing orders to
Lord Chief.
calling him to court. MS Bora, learned standing counsel. Submits that she is unable to obtain the required instructions in respect of the directions contained in the order dated 27/06/2023. She prays for further time. Full stop. The court as a matter of Last chance, the learned council is permitted time till Friday, which is 21st July, on which date the learned standing council will obtain the required instructions as directed by this court. By its earlier order dated 27/06/2023. Mr. G. Kapoti, learned council, appeals for the petition. List on Friday, you get your instructions on Friday.
Friday, Lordship.
Friday, 21st.
Item number 8,
No, 6 and 7. Adjournment Bizarre na. Mr. Dasgupta. I think item 6 and 7. 6, item 6. The learned CGC prayed for an accommodation because she has some other matters, so we can try calling it up in the second half, subject to your convenience. At 2 p.m. At 2 p.m. Please inform her. Yes, number 7. 7. Then 8. Okay, 8. Yes.
By this decision, we are currently having minutes of district level committee that is 28/6. That is minutes.
28, page number.
Annex 4, page 31.
31.
The exact name of the petitioner on the ground of the
Your name is?
Rupali,
Okay.
page number 31.
Overage.
Yes, sir.
Hmm. What does the, this is a finding of the DLC.
Yes, sir.
On which date? Date of the minutes?
28/6.
Please, 31.
28/6/2007. Sorry, 17. And which circle OM is in place? 2015.
2015.
So 2015.
I have a copy of it.
Now we have it. You were asking for compassionate appointment in which department?
Forest.
Forest. What is the provision regarding overage?
Block 60. Block 60.
16.
What, yeah.
Yes.
Apart is to be put to shit. Very much fun.
How old are you?
That type of it.
43. And what is the age limit? 40. 38.
44.
What is the age limit? No, guess. There is a circular. Where is the circular? There is a circular where it says the upper age limit for government jobs will be. It was initially 38, then it was increased to 42, then it went up to 44 perhaps.
44.
44.
That's 44.
44 when? Get the circular. Get it at 2 o'clock. Get it. It is available. What is the upper age limit that you want condonation? If it is 44, you don't require condonation. How old are you? How?
Only on Thursday. Because Saturday is not available.
It is not available. You can find it. Must be little more active.
44 years in case of without
In case of
in case of without
Reserve category, yes. And how old are you?
At the time of the.
Mr. Gogoi, you have it?
Okay, I will be looking to it also. I'll get it. Circular. I don't have circular with me right now.
At 2 o'clock?
No, no,
All right.
Hello.
Items 11 to 13.
Here in this case, today in the morning, I have got 2 orders. One order appointing the petitioner for 11 months as driver. And the next is the joining the board, here joined on purpose line. Okay, no, I got a copy.
So we are closing this? We can close it?
Yes, okay, I have already joined.
You have already joined.
No.
So your grievances have been taken care of?
No.
No further grievance?
He was on the temporary engagement. Honorable Court, Lordship may kindly see the order. 3520/2019, and you take up petition 3520/2019.
Yes, page number.
No,
There is an order.
there is an order in that page.
Order dated.
Honorable Court has observed that if some person is required, then he has to be given the engagement.
31/5. 31/5.
Yes, no, 31/5. If any kindly see that.
Daily driver is to be
If any
employed.
driver is to be employed on contractual temporary stopgap arrangement.
He is
Then
to
on
be-
regular basis, the petitioner shall be appointed after expiry of the term of the contractual appointment of the petitioner in May 2019.
All right.
Now, on first of June, he has joined for 11. Sorry, on July.
On July. And what are your prayers here? The repetition.
Prayer which you will find at page number 11 where it starts. Kindly come, the above, under the above pattern circumstances, it is most respectfully prayed that your lordship could recently be pleased to accept this application issue good following up on the respondents to show as to why. The pattern termination dated 17/5/2019 terminating the service of the petitioner very shortly as driver from messenger should not be segregated part. So for the records and upon hearing parties, your lordship is pleased to graciously make the rule absolute. He praised for his engagement. On 17/5/2019, he was terminated. Finally, on completion of that particular period, he was disengaged.
All right.
Purely a contractual engagement is for 11 months. Then copy I have to.
All right. Heard learned counsels for the parties. It is submitted by Mr. D. Nath, learned senior government advocate, that in pursuance to the directions of this court, dated 31/05/2019, passed in WPC 3520 of 2019. Wherein it was directed that if any driver is to be employed on contractual temporary stopgap arrangement, unless on regular basis, petitioner shall be appointed after expiry of the term of the contractual appointment of the petitioner in May 2019. Also, in terms of the directions issued by this court, the petitioner has again been appointed on contractual basis for 11 months with effect from 27 June 2023. It is submitted that the petitioner has also joined in the same post by his joining letter dated 1st of July 2023.
This post was written because the incumbent, he left the job to join some government job. That's what post qualification and PhD.
The post in which the petitioner had joined had fallen vacant as the earlier incumbent left the job and joined in some other department. Also, copies of the order dated 27 June 2023 and the joining letter dated 1st of July 2023 which have been produced before the court by the learned senior government advocate is kept as a part of the case report. MS, your name, madam? Sorry, MS so learned counsel appearing for the petitioner does not dispute this position as submitted by learned counsel for the learned edition of the senior government. In that view of the matter, the writ petition 3520 of 2019 stands closed. Interim order if it stands vacated. Then what happens to the other writ petitions?
The 2016 writ petition is challenging a termination order issued in 2016. In fact, the petitioner was engaged for 11 months from time to time.
That is again become infractions now.
It has become infractions. After
The,
2019,
then you take down WPC 1313. In this said writ petition, the petitioner had challenged the termination order issued under memo number ASCPR within bracket B 6/2014/42 dated 20/02/2016. Page number 30, whereby the petitioner was whereby the
page 31. That particular order, 20th of February 2016, page 31.
31, whereby the petitioner services were terminated with effect from 20/02/2016. Full stop. It is submitted by the learned senior government advocate Mr. Rinath that in view of the recent order dated 27/06/2023, whereby the petitioner has again been engaged on a contractual basis as a driver for a period of 11 months with effect from 27/06/2013, and in which post the petitioner has already joined with effect from 1st of July 2023. The no further pause. The issues are no longer alive in the sacred petition. Full stop. Learned counsel for the petitioner and so does not dispute the contentions raised by the petition respondent. Government counsel. The petition 1313 is accordingly closed and disposed of. Interim order if any stands vacated. Then the third. There is another writ petition.
Another writ petition. This is the 2620/2016. This is challenging another order of 2016, 5/4/2016. At page 38. You are discontinued by that order.
So this also closed.
Yes,
This also we can close it.
yes.
Similar order.
All engagements are for 11.
Yes.
Not
Yes.
5. Not 5.
Page number 38.
Page 38.
Page 38, 5/4/2016.
5/4/2016.
Same order. Disposal. Interim order if any stands vacated.
No.
Yes.
On hearing item number 14.
Yes.
Well, the petitioner is good and wants it, being agreed by the election of the part of the authority Not rectifying the data got in the service record of the petitioner lawsuit. Lawsuit. The fact of the case is lawsuit, the petitioner joined as a watchman in the Food Corporation of India on 1/4/1997 law. And thereafter lawsuit. The first application was.
What is his date of birth?
His actual date of birth is lawsuit 10/10/1956.
Hmm.
And the first application was given.
And it was recorded as, it was recorded as what date?
It was recorded as 3/5/1954. 3/5/1954. Whereas his actual date of birth is 10/10/1956. You are still find my first application at page number 10. The copy.
Hmm.
It is my main object. This was my first application. 4/10/1980. I joined in 1/4/1977 lawsuit within 3 years. From some days lawsuit, because as per FR 56 provides for furnishing an application within 5 years of joining the service law. FR 56 provides. Lordship, I have submitted this application on 4/10/1980 within 3 years. For 5 months. And this application has been duly received, lordship is find at the left hand side, bottom side, that they have received the copy.
Hmm.
They received on 4/10 itself.
Then,
Subsequently, lordship, again, I submitted another reminder, second application on 8/4/1982, which is in page number 11.
Hmm.
Now, lordship, but there is no correction made in my service record, lordship, the service.
Hmm.
Subsequently, I have been promoted to the post of trusting operator. By order dated 26/2002, lordship will find in page number 60. Page number 60, lordship.
your date of birth according to you is 10/10/95.
According to
56.
10/10/1956.
56.
9/10/1956. And lordship is kindly very, page number 16, lordship, the promotion order.
And this you are making a statement on what basis? On what basis?
Birth certificate.
Where is the birth certificate?
Lordship will find a birth certificate in page number 30.
Hmm.
Annex B, page number 30.
And this you had taken out in 1978.
Lordship, this I have taken out in 1970s, lordship, because lordship, that I have explained in my additional affidavit, lordship. Why this I have taken out.
No, but there is a procedure for taking it out.
Lordship,
Has that procedure been followed?
lordship. Lordship, I have filed my additional affidavit also here.
Hmm.
Lordship, you find in paragraph 5 of my additional affidavit. I have explained, lordship. That's why denying the statement, lordship, I will lordship.
Yes,
Additional affidavit,
additional evidence.
additional affidavit filed by me, lordship.
Yes, additional or reply?
Lordship, reply.
Reply evidence.
Additional affidavit is reply, lordship.
Yes.
That while denying the statement.
Page number, page number?
Page number 41,
Yes.
paragraph number 5, that while denying the statement made in paragraph 7 of the affidavit of opposition, the defense begs to reiterate and reaffirm the statement made in paragraph 3 above. Further, the application dated 4/10/1980 was duly received by the concerned dealing assistant, and the application dated 8/4/1982 and 8/9/2002 were in good faith handed over to the concerned district manager FCI as being a grade 4 employee. As a matter of courtesy, the department did not ask the receipt from the district manager. As regard to the allegation of non-submission of the original birth certificate issued on 15/12/1979, the department makes stated that as he lost the original birth certificate during the period of psychological disorder.
Now, who will certify that this is the original birth certificate? It is the authority concerned.
Lost.
Do you have any certificate from them?
Lost.
Yes, health department,
of Britain.
health department? Your original birth certificate was lost.
My original birth
You
certificate-
supplied a duplicate birth certificate.
Lost. I applied for the.
You applied for that.
Lost.
So do you have the necessary documents available?
Here also I have put the birth certificate also kindly there is annexure P page 13. Date of registration is 13/12/1970.
Hmm.
Date of registration is 13/12/1970. Page number 13 of my.
Yes, yes,
And date of issue is 15/12/79.
79. That is all right.
13/12/1970.
But there must be some record available here. This is issued by which department? Government of Tripura.
Government of Tripura.
So there has to be somebody to, some certificate that yes, relevant documents or register are available here. It is your case that you have supplied a duplicate certificate.
Yes.
Now, how will the authorities verify that?
So in that regard, on the basis of the documents furnished by me and also they have issued the certificate.
Correct, but they'll have to, somebody will have to verify from the Department of Health in the government of Tripura.
No.
So if you have the relevant certificates or relevant documents to say that yes, this
On the
document
basis of which the certificate was issued.
was issued or the registration number is such and such in the register,
Yes.
then the department can verify. We can issue a direction.
Also here is not, all I can say is what, the necessary documents were furnished to the department, the concerned authority for issuing the certificate also.
What department, what documents?
The document at the moment is not available with the office.
Then,
You will obtain instruction whether.
no, what instructions after all these years? What instructions?
What are the documents they furnished at the time of applying for this purpose? Otherwise also. Here also otherwise, my three and third application was again,
You have asked for an order, you have prayed for setting aside of this repetition, of this order.
this order. Where also they have rejected for correction, being a belated claim. Plus, FR 56 provides for a period of 5 years. For
Let us see 56,
FR
FR 56. Your copy is not found available in the office. There are 5 of the affidavit in opposition.
There are 5 of the evidence opposition also. In regard to that application of court in 1980 lawsuit kind of scheduled in the petition lawsuit, they have duly received. They have not denied that they have not received. Yeah.
Now come to page number 35. Or page number 15 of the affidavit in opposition. 1515, annexure B of the affidavit in opposition. Fundamental rules है कि नहीं?
Connection of it. B lawsuit.
हाँ, annexure B.
Connection.
Oh, yeah.
This would be the observed that the date of birth of the police officers are not mentioned properly, they have admitted lawsuit. Not verified by the FCI authorities at the time of opening of the service. So you are hereby directed to submit at the earliest the date of birth certificate documents to verify the date of birth as desired by the regional official. This is a 28/8/2002 law.
Now, what is your response to this?
Here also, prior to this data also, we have covered.
In response to this letter,
Data was never received by the. Data was never received by the, I will state it in my reply. But prior to that, I have made three.
no, why you're hankering on that application prior to that? If you have not received this affidavit was filed when? This was filed on 2014.
But prior to my lawsuit, even on 1/6/2000 bill, I have represented lawsuit for correction of the data, but based on which they have passed this in order rejecting my application on the ground of belated.
Yes, madam.
Because I'm actually on behalf of my senior, Mr. Vacancy. My lord, actually we have recently been engaged on May 2020 by the FCI. So we have to obtain the savings of the case.
You have been what? Sorry.
We have to obtain savings of the case. We have to obtain.
This is a 2013 matter. Where is Mr. Singh?
And the previous out of. I think it's.
When is he available? When is he coming back?
Tomorrow or day.
We'll take it up on Thursday to call him, inform him.
Thursday.
Coming Thursday. You get your instructions on Thursday. 20, 20 July. List again on Thursday. 20, at the request of MS. V. Bora Learned Council appearing on behalf of Mr. BK Singh, standing counsel, a learned counsel representing FCI. Mr. Vaidya appears for the petitioner. Huh? You inform him, we'll close this matter on Thursday. You are entitled to We permit you to go through a copy of the second copy of the court's file if you want, or the writ petition. Do you have extra copies?
I will provide.
You furnish her one copy.
Item number 15.
Yes, Mr. Smith, you're not appearing in this matter?
Still related to the application of the quotas.
Yes,
We don't like to, another petitioner, like, what's the. Case, even that waiting for an instruction.
sorry.
In the petition, like, what's the matter?
Does not want to pursue.
I don't think all like, we are trying to, instruction, we are waiting for instruction, and.
You get it by 2 o'clock.
We can try to consider that. Can it be on Monday or next?
What matters pending. One telephone call is necessary. One telephone call is necessary.
But the telephone code number wasn't written in the file. That was. And on
What Monday, day after tomorrow, get it.
the day after, I will not be there, but on Monday.
You get somebody study, you request one of your colleague to be present. We would have taken up this matter at 2 o'clock. If you want, we can take it up at 2 o'clock.
Yeah.
Day after, okay, day after.
Item 19.
Hmm? Can't hear you. Might come on it. Yes, your senior is on legs, you are available. What is the matter? What is the matter? Hmm.
After the same day, and he was done with the charging, he submitted his resignation letter.
Hmm.
He was provisionally released from service on the same day.
Which department?
Uh, yeah, to pick the UK Nair, he had to pick the UK Nair for the respondent
You are for whom?
and for the petition.
So how are you concerned who's appearing? You are appearing for the petitioner. So if no one is appearing for the respondents, it is their headache. Why are you concerned? Gas company. You are employed in the gas company.
Yes.
Yes, Mr. Nair is here.
Lordship, my senior is having some personal difficulties.
No, he was here in the morning. He was here in the morning.
Yes, he had to leave.
Why?
So, this first. The matter will taken up on Thursday.
Yeah, our entire list is fixed up on Thursday. How many matters do you want us to take up on Thursday? 2020 matter. Let it go to the regular hearing list. This is for hearing. All right. Thursday, at the request of group councils. Thursday.
Part 2 hearing list, item number 61.
Item 61.
Yes. Next.
Item 62. Sixty-three.
Yes.
64.
Call up at 2 o'clock. On the page where this meeting. Yes, you have any matter?
So it was 75. If the time is set as what is the.
75. We'll call it at 2. The file is not here. Yes, anybody? Hmm. 106, 107. You're for the respondents. Petitioner will have to inform. Thursday.
Time being item number 6.
Yes.
Look, the petitioner, the member of. He is working as a leading handbag.
You're working as a
Leading hand. Now, he was promoted from the post of pager. And prior to that, he held the post of called pioneer. This post is equivalent to the overseer rate. Now, this overseer scale of the pay of the overseer was revised. And as that scale was not extended to the non-diploma holders. And by virtue of the judgment of this honorable court below, this scale of pay has been implemented to the all persons who are working as a worker, whether he is the post of diploma or holding diploma or not. Now the petitioners is now, this lead petition is for equation, for the extension for the scale of pay which is being paid to the overseer to the leading faculty. This is by basic case before you.
they are at the same grade. Are they equivalent posts?
Yes, they are equivalent. That is the apparent form. The recruitment rule. You will also will find it. Page 40. And it's a 9. Relevant page is 41. Leading hand. Non-technical.
Yes.
Scale of pay there. That was in the year 2020.
And what is the scale of pay for overseer?
And
Overseer?
over here we find at page 42.
Yes.
We are to find scale of pay. So go through the scale of pay. You will find. Now,
Yes.
once the overseer is concerned, can be recruited for through BH recruitment or to promotion. The direct recruitees are to require to hold the diploma. And promotees are not required to hold it. At one point of time, the 6th commission recommended for upgradation of the scale of pay to the overseers. That will also will find that annexer 1, big article. Overseer border route organization.
Yes.
Now, highest merit. Higher scale has been demanded for the post of overseer civil in border route organization. On the ground that the minimum qualification for the post is diploma in engineering. The post carries minimum year recruitment qualification of diploma in engineering. These minimum qualification has been prescribed in 1996. CPC in their report submitted in 1997 had recommended the scale of pay of rupees 5,000 to 8,000 for all posts carrying minimum direct recruitment qualification of diploma in engineering. This recommendation was accepted. The post should consequently have been extended to the scale of 5,000 to 8,000 with effect from 1/1/1990. This was, however, not done. The commission accordingly recommended that the post of overseer may be updated and marked with the promotional post of superintendent PR grade 2 present scale 4,500 to 7,000 and the combined cadre extended the scale of rupees 5,000 to 8,000. Since the commission has recommended the merger of higher scale of 5,000 to 8,000, rupees 5,500 to 9,000, etc., the post will be placed in reverse band, etc. Now, look, these benefit was only extended to the person concerned who are holding diploma. The person concerned who do not hold a before they were not getting this benefit. As a result, the case was brought up in higher bench. And thereafter, it was also came the division bench. Now, ultimately, the judgment of the read petition, which was affirmed by the division bench, was that the person concerned who are not holding the diploma holder, they are also entitled to have this scale of pay. That is one portion of my story. Second story is that there are other persons who are working as mason and painter. The mason, those who are working as mason, they are promotional post in department. The person concerned who are working as painter, their promotional post is leading handpan. Both are equal.
Where do you say that? From where do you say that?
Yeah, that is a department point. That will be. Judgment of this honorable court, at page 26.
Yes.
Let us start from paragraph 3.
Okay.
In the meantime, the report of the 6th State Central Pay Commission published and accepted by the Government of India, which was to be implemented with effect from 1/1/2006 by enacting Central Civil Service Revised Pay Rules 2008 by notification number such and such dated such and such. In paragraph 7.39.2, just now I have read it out. The 6th State Central Pay Commission the post of overseer has been updated and marked with the promotional post of superintendent PR grade and fixed at rupees 5,000 to 8,000. After implementation of sixth pay commission by the appellant, the overseer working in border road organization for to be short BOD, BRO are having diploma engineering has been allowed the pay scale of 5,800 with effect from 1/1/2006. But the respondent, though promoted to the post of officer, overseer, way back on 5/6/1990, has not been allowed to enjoy the scale of pay of rupees 5,800 with effect from 1/1/2006 till date, on the ground that he is not having diploma in engineering. On account of creating some confusion regarding the pay fixation in respect of overseer in PRO, Chief Engineer of Project Pushpa, care of 99 APO, filed letter dated such and such, informed that the such anomaly to the Director General PRO, Srimastod of Bhavan, such and such, Delhi Cantonment, New Delhi. The Director General PRO, in reply to the letter indicated that indicated above, informed the chief engineer that the pay of the non-diploma holder overseer PR2 and such may be fixed in the corresponding payment of fee reversal. On the basis of the letter of the Director General, respondent has not been allowed to enjoy the state scale of rupees 5,000 to 8,000 as recommended by the Sixth State Central Commission for the post of overseer
This is
and
with,
accepted by
this is with
the
regard
government
to-
of India.
this is with regard to overseer.
Yes,
Now, your case is leading hand. Your client is a leading hand.
yes.
Now, how do you draw the similarity or parity between overseer and leading hand?
That they have. Basically, they are of same grade. Having same scale of thing. And if you are lucky, come to their affidavit, you reply, affidavit in opposition, what they wanted to say. Their case is that. What, in this, their case is that. A person concerned who is posted for as an overseer, he is entitled to have this scale of pay. But the person concerned who is posted as leading headman, he will not be entitled. Though the post are same, sorry, equivalent.
No, they are denying that. They are saying the nature of duties are different. The
No, that is their case. Their case is that the
nature of,
person concerned who are holding the post of promotion, post of overseer through promotion, they are entitled to have this scale of pay. But the person concerned who are not holding the post of promotion, though they are equivalent post, they are not entitled.
no, they don't say it is equivalent. They say that the nature of duties are dissimilar. Which, there are 5 of their affidavits.
Now you have to come to the affidavit in opposition. There are 7 or there are 5.
Yes.
The different begs of it that the instant writ petition is devoid of any merit and does not need interference of the honorable court as no indiscrimination or injustice has been done to the petition. However, a brief fact of the case is put forth in a succeeding paragraph for benefit of the honorable court. Passing. The petitioner states the leading hand, administration Mikhilesh Kumar David, this is the petitioner, was appointed on 22/8/1988 as a pioneer with the qualification of matriculation. While serving as pioneer, the petitioner promoted the post of painter with effect from 5/9/1990 through Departmental Promotion Committee. Subsequently, he has been further promoted to a leading and non-technical with effect from 2006, 117C. It is pertinent to mention that as per R and P rule, the next promotional post of painter is leading hand. Leading hand, non-technical, which has now been redesignated as leading hand administration. Painter to leading hand is the next promotional. It can be designated from the nomenclature of the post itself, that is post leading hand is a non-technical one and non-technical one, and nature of duties to be dealt with the generality. Now, if you look at paragraph 7. Here, this is the petitioner has filed the patent lead petition seeking grant of scale of pay 5,000 to 8,000 with effect from 1990, which has been granted to the overseer, which is a technical post and minimum entry level qualification for the direct recruitment is diploma in civil engineering. It is pertinent to mention here that DS such and such overseer Kattarchan was promoted to overseer as per his natural channel of promotion from the post of master, as per the recruitment and promotion rules of 1992. That is why master is the PD category for the promotion of the post of overseer, non-diploma holder. Master who are matriculated with 3 years regular service in the grade of general reserve engineering course are eligible for promotion to overseer, non-diploma holder, subject to the passing of trade test, where the promotional post of painter is leading hand, non-technical, later reading the leading hand, and the petitioner was promoted to the post of leading hand administration on fulfillment of all criteria defined in our field, R&D. Now, as per Honorable Guwahati High Court, ideal paint ordered at such and such, passed in such and such, directed the respondent authorities to revise the pay scale of the petitioner who is working as a regular worker at the scale of rupees 5,000 to 8,000 per month.
No, Mr. Dasgupta, how are you trying to draw the parity, similarity between the case which was decided in ISO regarding overseer, that is benefit of pay being granted to overseers excluding the diploma holders. The court said give it to diploma holders. Here is a case where the department is the department's case is that you belong to the non-technical branch and your line of promotion is feeder post is painter, then you become a leading hand, etc. So far as the overseers are concerned, their channel of promotion is different. Now, merely on the scale of pay, will it be sufficient to conclude that nature of job and etc. are all same and similar?
Recruitment rules is also same.
Would be.
Recruitment rule of same scale of pay, same.
You have to show us the nature of duties.
Merely.
There has to be some similarity with.
Technical and non-technical.
No,
You
but
want to distinguish these things, my post is non-technical and the overseer post is technical. As it is a post of technical nature, their scale will be different, and my case is not in the technical nature, my scale of.
you have to show us some authorities that mere change of or mere difference of nomenclature is not sufficient to deny the similarity of scale of pay. Because otherwise the judgment you are relying on is exclusively on the question of diploma holders and non-diploma holders.
But I was the one person who is promoted from mason to overseer. And one person who is promoted to painter to lady headman. Their scale of pay is different. But though the feeder post they are same. Mason and painter are of the same thing. Mason is promoted to the post of overseer. The moment he got promotion to the post of overseer, his scale pay will be higher than that of the person concerned who
But
was
so are some.
from the painter to leading it.
No, what is the basis of that argument to say that merely because their feeder posts are same, the scale of pay in the higher post must also be the same? What is the, on what basis are you making this argument?
No,
Unless you want to
scale
say,
of pay of the feeder post was same. And the moment they got promotion, their scale will be.
is it a case that a painter can also become an overseer? Can a painter become an overseer and vice versa?
Painter cannot become an overseer, painter can be lead, but a mason can become an overseer.
Can a
The
mason
scale of
become
pay
a,
of painter and mason are same.
can a mason become a leading hand? No,
Mason become overseer.
overseer, that's right. So their channel of promotion is defined. The rationale of having different scale of pay
Of the promotional post.
of the promotional post. Mainly because the feeder category post was having the same pay. Does it depart the authority from having different scale of pay in the higher post? If the nature of the job, if the nature of the job is different,
Merely because one is performing technical nature of job and the other is performing non-technical nature of job. For that reason, whether the scale of promotional pay may be defined.
would be different. It is up to the wisdom of the authorities
Because of the nature of job.
because of the nature of.
Only their only contention is that because of the nature of job,
The nature of a job of a mason and a painter, as per common knowledge, is definitely different.
yes,
Now, whether a mason and a painter should be at the same category or not is a decision taken by the authority.
they
According
were in
to
the same category, that is apparent from the recruitment group.
no, in the subsequent posts, in the higher posts.
Okay.
For what reason it is only a mason who can be promoted to an overseer, and why not a painter? That rationale is not here. Your only ground is that the parity must be maintained because the nature of the job is the same. That is number one. And-
Feeder post parity was there. The
Feeder post
promotional
parity was-
parity is not there.
So you have any authority to rely on that in support of your submissions?
The latest public there, but this was-
They have to support. Yes, madam, why divide him?
Lordship, their nature of job already Lordship had pointed out, Lordship, and these issues have been dealt by Delhi High Court, Lordship. I have annexed the
Delhi High Court did not deal with any issue.
Yes, then they-
Delhi High Court did not, with all respect, respect.
Lordship, here they are challenging
Delhi High Court closed the issue on the ground that these are two different
non-technical and technical.
technical and non-technical, but whether nomenclature itself is sufficient to distinguish when he says that the feeder posts, they were in the same category.
Lordship, they are totally administrative work, and they are the other overseers, their work are related to engineering, civil engineering, and they are challenging the Carter Singh was promoted. He was from Mason, but he had also passed a special trade test to become an overseer. His speaking category was Mason, then he passed a special trade test to become an overseer.
No, from a painter, are you promoting people to
No,
overseer
no.
and vice versa?
No, from pioneer to painter to leading hand. Earlier it was non-technical, now it is administrative. And from mason, then he become overseer. After passing the qualification necessary civil engineering, then also if mason pass special trade test, he can be promoted to the post of overseer. That is what is done in the case of Carter Singh, from with whom they are asking similar pay scale law, but totally different law. Maybe
No,
the pay scale.
where in your rules do you prescribe that having diploma is a condition precedent for getting the higher scale of pay or getting the promotion?
Lordship, my affidavit, I have annexed lordship. And case 29,
Oh, yeah,
71 is the continuous base lordship.
71, okay. Yes,
Please, 29. Leading non-technical lordship, name of post. The name of post means scale of pay, etc. duties to assist change of gain of workmen, estimate and extreme right and corner lordship and maintain direct recruitment, estimate qualification, civil engineering diploma, matriculate with 3 years experience lordship and next lordship, then was here come. Over here, about previous page, page 70. 28. This direct recruitment, age limit 35 years, relaxable to 40 years, qualification, pass matriculate and overseer certificate from IB so and so, or
Is-
state government.
no, this is
Page
for,
7,
this is for direct recruitment,
yes, Lord.
for departmental promotion.
Engineering diploma, such candidate will be given a higher rank or matriculate with 3 years experience of engineering construction. Grade from which promoted lordship, bricklayer, mason, then this lordship, but here painter is not there lordship.
No, what are these? Not very,
Departmental
Clear.
promotion, bricklayer, mason,
uh,
this
That-
is not painter lordship, then this is concreter. These are the, painter is not there lordship.
and what is the last word, last term?
Last one is mate, MATT, 28, 29.
What is the meaning of mate?
Mate,
So if you come to page 71,
perfect,
at the last heading, departmental promotion,
perfect.
you will find grades from which promoted mates are mentioned.
The mates are not painter lordship, there,
No, grades from which promoted.
yes, lordship.
What is the rationale?
Grade from which promoted maid, driver, MP for leading an appointment in transport. Platoon
No,
store,
no, mate is one of the posts. Mates,
lordship.
which is also found in this,
There it is the last one, here it is the first one, but painters is not there in my lordship, but there. I only have to painter and painter to leading and non-technical, now it is leading and.
you were appointed as what initially?
Pioneer,
Pioneer.
That is clear from their attitude. So pioneer, then painter, then leading it.
Not as a mate.
Pioneer, painter, major. Painter and masons are of the same people.
Not only painters, there are bricklayers, carpenters, mates. But for promotion, the channel of promotion for overseer and leading hands are specific. What is the rationale behind it? Is for you to submit and say that there is no
For the promotional. post,
rationale. There is no-
Especially the scale of pay in the promotional post. Yes, no. Yes, not getting. This nation.
no scale of pay may be same, but the nature of works are different.
What's the define
Then-
according to them? They want.
For some nature of works, there is some channel of promotion. How can you say that this is discriminatory? Some nature of works, there are certain channels which are fixed. That by itself will not grant you similarity of pay.
paragraph 9 of my case, I have stated the duties of both
You have not said anything regarding the rationale. What is CPL? Yes. Some basis to support your contention. We can, if you want, we can take it up on Thursday. If you want, we can take it up on Thursday. But we want some
The
basis.
only thing that I have to say before the lordship that in a promotional post, scale may be different. That is scale may be different because of the alignment of the nature of job.
But
That
your
is a
your
promotional
contention.
post.
Your contention is when the feeder post is scale of pay is same. Why there is a difference of scale of pay in the
The
channel of promotions?
their contention is that they support the duties of the promotional bids are different.
It is, they have specifically averred in para 9 of their
Right,
affidavit. So if
As the duties are defined, so the scale of pay may be different. Only thing that.
after hearing Mr. A. Das Gupta, learned senior counsel, assisted by Mr. So-and-so, Mr. MSP Sharma, learned in CGC.
On ideology.
Private. Why?
Again, I have to take some accommodation because already 3 cases
All right. Matter be taken up again on Friday.
of life.
Friday. 21st.
Item number 7.
Yes, Mr.
You have to challenge this to some experts remarks given in the ACR of the petitioner. It led to him suffering and him being downgraded from the benchmark of very good. And therefore, which is now suffering the cost of his promotional gain.
What does the OM or the rule say?
But OMN rules 1.5. So the reviewing authority has the power to review whatever has been given by the reporting officer. Here is a case where the reviewing officer has taken into account incidents or orders or displeasures being granted to him after the period for the APR was,
After,
the period for the APR was. For example, when the APR was from 2018. first
you
of-
mean to say that certain situations or displeasures were taken note of, which does not relate to the
Yes, that
period
the
under
displeasure
consideration.
was not given. The displeasure was not awarded to him. During that injury. That is one aspect. The second aspect is matter. He has referred to a departmental procedure. While downgrading me, whereas on that particular day, per their own reports, there was no departmental proceeding against. Thirdly, my lord, when I had made an appeal against the displeasure. The Director General of the Testing Force has given an order saying that this displeasure will not be taken into account while considering his APR for the application. Despite that, that particular displeasure was taken into account was not removed. All this were together proves that my APR for that particular period was not properly assessed. And what was given by the reporting officer had to stand, which was just the benchmark required for me being considered for future promotions. Typically, I don't know when they take the ACS for 5 years consecutively for considering me for promotions. Now, 2018-19 APR being kept below benchmark, till 2023, I do not have any option of being considered for the promotions. That is how it hampers my service career. That is why I am so many saying that these particular APRs will have to be. The downgrading of the APR from very good, as given by the reporting officer, to good by the reviewing officer, where teacher interference.
This APAR is to be filled up by the officer concerned.
I make a report of myself.
That's
I
right.
say that this is what I have done.
Which is agreed to or disagreed by the reporting.
Officer, they have to gives me certain marks. He either agrees, disagrees, then he puts in certain marks on certain columns.
So he gives you
Very good,
very good
which is the benchmark. The reviewing officer
downgrades.
says I disagree, takes into account these little things, downgrades me to good,
And then accepting officer,
accepts it,
the reviewing officer's views.
the reviewing officers. And thereafter, when I make an appeal for the 3 displeasures that were taken into account, one of the displeasures, the DG says, don't take it into account while writing these APIs. It is not such a good. But the API is not thereafter also reviewed. Since my downgrading was dependent upon one of such displeasures, it had to be reviewed once the order of the DG came. That they did not.
Review was not done.
That review was not done. Again, my the reviewing officer, when downgrading me, has stated that there is a departmental proceeding pending against me.
No. That is while reviewing or after the order of the DG.
No, while reviewing me first time only, he said there is a departmental proceeding. There was
But
no
that was-
such departmental proceeding.
That was not highlighted by the DG.
Madam, I did not, they have stated here on my certificate, they give me reply saying that and keeping me on representation while disposing of the representation, they do not take into account all these things. They simply say nothing new has been stated, your APR good stands. Without discussing those things. That is the crux of the matter.
And what is the department's view?
I will also. I left and it is going in the judgment that I was referring to. Somehow this was the level of principle. Another judgment. To be taken up on Thursday. Next week. On next Tuesday also, I will have those to show me that the APRs can be.
Pass it over for this week. Next week sometime. We'll not fix a date. Fix a date. You want us to fix a date? If it goes to first week or second week of August.
First week of August.
3rd of August. Joint request matter is deferred till 3rd week of August. Third August.
Item number 8.
Yes. When?
Memorandum declared on March 2006 and by this.
Where is the OM?
By this particular case in the case is extended to 5 years. For all the cases.
So 38 plus 5 would be 43.
43.
43. And how old were you?
He was 43 or no, 40.
43
Yes, sir.
on that day.
On that day, the time of making the application, she was 43.
No, on the date of making application.
Yes, sir.
When was the application made? Two 2016.
Month.
What was the date? Date is not very clear. On the date of the application,
There's no date.
page number 20. What is page number 20?
The file copy.
Of what?
Okay, sorry.
Application. So what is the age you have reflected? Date of birth, serial number 2C.
1972.
So what will be your age on the date you have furnished this application?
Because on page number 24, there's more than a copy.
But there is no date. On which date have you calculated 43 years?
We go by the date of birth of 1972. Never 44 years.
Where is the original copy?
Then the book is submitted.
No, you have typed it out from some copy. Your husband expired in 2015.
Yes, sir. 9/12/2015.
So when did you apply?
February 2016.
2016. So what will be your age if we take 72? You are about 44 years.
Yes.
So by this also you are excluded. This is 38 plus 5 would be 43.
43.
Lordship, as per the notification of 2015, clause 16. Upper age limit could be extended by regard of the but there is no specific that IBR 3 years, nothing with it. Only 18 years is fixed. It should not be less than 15 years.
Where is the order of the DLC again?
This number is 26 onwards.
Hmm? No, your case, where is it considered? Page number
31 is the
31.
yes, top. Only from. Claim has been rejected on the ground of correct process.
It says as per the existing government policy, clause number 16.
Yes.
Of the OM. Upper age limit. Wherever found necessary. Can be relaxed. As per the existing government policy. So existing government policy will be this. Which is 43 years.
But the upper age limit to be relaxed whenever found to be necessary as per existing government policy. It's not a completely fixed. Then,
Now, what is the government policy for relaxation? You can't go on relaxing whatever age. There has to be a policy. The policy is this. What is the policy? Is there any policy for that?
because as per my understanding, but the definite policy for that. There is no definite policy for that.
All right, heard Mr. A. Sharma, London Council. For the petitioner, Mr. R. Gogoi, appearing for the respondents.
2, 3, and 5.
2, 3, and 5, Mr. J. K. Goswami, appearing for respondents 1 and 4. The petitioner before this court is aggrieved by the minutes dated 28/06/2017 of the DLC Sunitpur. The minutes of the meeting of the DLC committees, DLC Sunitpur. Full stop. The DLC Sunitpur rejected the claim of the petitioner for appointment under the scheme of compassionate, for appointment on compassionate ground on due to overage without considering the relevant provisions specified in the OM dated 1st of June 2015, which was prevalent at the relevant point in time. Era. The husband of the petitioner was working as Forester -1 under the office of the DFO Sunitpur. Also, the husband of the petitioner died in harness on 09/1/2015 while he was in service. It is submitted by the learned counsel for the petitioner that at the time of the application for consideration of our case for compassionate appointment, the age of the petitioner was about 43 years. Full stop. The petitioner submits, it is submitted that the petitioner was left with no source of income after the death of her husband. And was also required to look after one minor child. The husband of the petitioner died in harness after rendering about 25 years, more than 25 years of service. So, where the learned counsel for the petitioner submits that the petitioner had obtained a diploma in typewriting from a recognized institute. And after completing all necessary formalities, submitted their application to the Divisional Forest Officer, Sunitpur, West Division, Sunitpur, Assam, for due consideration. Our application, full stop. The application of the petitioner was made within 1 year of the death of her husband. Full stop. Para. After the application was duly forwarded by the competent authority, matter was placed before the district level committee. Full stop. The district level committee, by its meeting held on. When was the meeting held? 28/6/2017. Rejected the case of the petitioner on the ground that she was overaged. Also. Learned counsel for the petitioner submits that the ground on which the case of the petitioner was rejected is contrary to the provisions of the OM dated 1/6/2015. So it is submitted that in terms of the provisions of the OM dated 1/6/2015, the department was empowered to relax the upper age limit of any candidate wherever found necessary. Full stop. This provision of the OM comma, as is submitted by the Learned Council for petitioner, comma, was never considered by the DLC while rejecting her application. Para. Learned councils are getting for the respondents submits that as per government notification, the upper age limit was increased by 5 years, making it 43 in terms of the OM dated 3rd of March 2016. Full stop. Learned counsels for the respondent submits that there is no infirmity in the minutes. There is no infirmity in the decision taken by the DLC, Sunitpur, in terms as per the minutes dated so and so. Therefore, the writ petition merits dismissal. Para, having heard learned counsels for the parties, and upon due perusal of the pleadings of the court, as well as the OM dated so and so, this court is of the view that this court is of the view that the OM dated so and so contained a provision whereby the competent authorities were empowered to relax the upper age limits. Stop. Para 16 of the OM dated so and so is extracted below. Para. In terms of the same provisions, the competent authority was empowered to relax the upper age limit wherever found required. Full stop. Wherever found necessary. Full stop. The lower age limit, however, was not to be relaxed below the age of 18 years. Full stop. The age eligibility was to be determined with reference to the date of application and not on the date of appointment. Full stop. The state level committee shall be competent to grant relaxation of the upper age limit for making such appointment as per government policy. Full stop. Para, having heard learned counsels with the parties and upon due consideration of the OM dated so and so, as well as on a careful perusal of the minutes dated so and so, which is included in the present petition, it is seen that there is no reference to the it is seen that the minutes do not discuss elaborately the basis on which the claim of the petitioner came to be rejected on the ground of overreach. Also, a perusal of the writ petition reveals that the application for compassionate appointment was filed immediately after the death of the husband of the petitioner. The date of birth of the petitioner is shown to be in the year 1972. If the application as stated to have been made by the petitioner immediately after the death of her husband, then the age of the petitioner would have been 43 years. Huh? "43 years on the date of making the application. Also, if that be so, then as per the OM dated 3rd of March 2016, issued by the Department of Personnel within bracket capital B, Department Government of Assam, the upper age limit as fixed by the government for appointments under various posts available under the government would be 43 years. Full stop. The DLC had considered the application in the year 2017 and had rejected the case of the petitioner on the ground of being overreached. Full stop. However, there is no finding by the DLC as to whether the application, whether the petitioner was found to be overreached on the date when she had filed her application before the competent authority. Full stop. The minutes of the meeting dated so and so of the DLC are bereft of such specific details. Full stop. Upon due consideration of the matter in its entirety, this court is of the view that the writ petition can be disposed of in the direction to remand the matter back to the DLC to reconsider the case of the petitioner for reconsider the case of the petitioner and pass a detailed order as to whether on the date of making her application, whether she was found to be overreached. Also, if on the date of making her application, she was not overreached, then the DLC will recommend her case to the SLC. Also, the SLC in turn will pass appropriate orders as required under in terms of the OM dated so in 1/6/2015 and grant such age relaxation if required. In terms of clause 16 of the same ON, dated 1/6/2015. Post office. The minutes of the meeting insofar as it relates to the petitioner, minutes of the meeting of the DLC dated 28/6/2017 insofar as it relates to the petitioner are hereby interfered with and set aside. The matter as directed is remanded back to the DLC, and the DLC will expeditiously reconsider the case of the petitioner and pass appropriate orders. The entire exercise be completed within a period of 60 days. 90 days,
Let's see, if 2 months, the PLC.
90 days,
90 days.
90 days from the date of receipt of a certified copy of this order. The petition stands disposed in terms of the above.
And
Part 2 hearing list, item number 75.
Yes,
if, part of the factors not to take the statement.
it is submitted by Mr. K. Polita, learned counsel for the petitioner, that he has instructions from the petitioners not to press the writ petition any further. Writ petition number so and so accordingly stands dismissed as not read. Interim order, if any, shall stand vacated.
Hearing list, item 65.
I need a matter when they adjourn for a day and it will be some Tuesday or
Tuesday. No, we'll not fix it on Tuesday. We are accommodating you for today if you want. Will you be available on Thursday if required? Yes. No orders are necessary to remain in the list.
66 and 67.
Yes, Mr. Goswami. Anganwadi. You go through the file, tell us. Thursday.
That's the program.
68.
Again, social welfare. You can take the second file if you want. Looks.
69.
Yes, Mr. Mazumdar, any matter? All right.
After 60, I will.
You take out the social welfare files and
I will.
whatever you need. Yes.